Welcome, everyone. Welcome to the CrossTech Compliance 2022 online conference. My name is Ana Karina Gonzalez, and I am thrilled to welcome all of you to our first session, the current state of regulatory network supervision. I am pleased and excited to be your host, and on behalf of everyone in the CrossTech Payments team, I welcome you and hope you enjoyed today's agenda. In this session, Kathy Tomasofsky, Executive Director of the Money Service Business Association, MSBA, will be moderating the discussion on the regulatory environment overview. We're going to define what is a network supervision and understand why did it started or how did it started, what is the current status, and where is it going. Joining us today, I'm very pleased to introduce our moderator so we can keep on understanding and learning more about the network supervision. Kathy, the floor is yours.
Thank you so much, Anna. And we are excited that you have joined us. If you're at the end of the day on the East Coast or maybe taking a lunch break on the West Coast. Whether you are a traditional money service business, money transmitter, whether you're a digital company, whether you're a wallet, a prepaid card provider, a crypto company, you really need to understand what network supervision is and how it affects you. And we are so honored to have two great panelists to help us do that. Today's agenda, let me take us through our agenda. Today, I'll introduce you. As Anna said, we're going to talk about network supervision. We're also going to talk about the MSB Model Law, which is the glue, I'll say, that holds network supervision together. We're fortunate that Dan will provide his legal as well as his ex-regulatory insights throughout the process, talk about the current status, and then give you some key takeaways. First up, we have Mary Pfaff, Senior Policy Director at the Conference of State Banking Supervisors. Mary, you have a great deal of experience. If you can share with us that. And I also think it would be helpful for our audience to understand what the Conference of State Banking Supervisors does.
Thank you, Kathy. And I will start with an immediate apology because my lawn service just showed up. So I hope you can hear me, and they should be gone soon. Yes, I'm Mary Papp. I'm the Senior Director of State Legislative Policy at the Conference of State Bank Supervisors, or CSBS as we call it. And my whole background's been in the state legislation of financial services. I will not go ahead and read all that, but I've been doing that pretty much my whole career. The Conference of State Bank Supervisors is a professional organization that represents all of the state banking departments in the country and in all states and territories. So obviously, we represent the regulators and their interests in Congress and in Washington with the regulatory agencies, but we also work with them on different state issues. Everything from, their examination issues, licensing, all the supervisory issues. And my job is to really just, track state legislation and work with the states, because if something's coming up in one state, it will most certainly come up in another. So, and as you all know, as you have licenses, you realize, there's a lot going on in the states. And, so my role is often very much of an information role, but we also, as we'll talk about today, with our model law, we've sort of stepped things up and working with industry and regulators to streamline and make more uniform the money transmitter licensing laws. You're on mute, Kathy.
I did it again. I'm trying. I have also people in the background, so I'm trying to do that as well. Next up, we have Daniel Wood. And Dan, if you can share with us your background, please.
Sure. I began my legal career with the state of Texas, working for the Department of Banking there, which regulated, of course, MSBs, among other financial services entities. Most of my time and energy went into the non-depository side, MSBs, and similar entities. I got to work with cryptocurrency stuff, like right after Bitcoin dropped, which was all very interesting. And I began going to CSBS conferences about 10 or 11 years ago. And after a 7-year career there, I came to the private sector, and I've been with Pillsbury, where I am now counsel on our payments and fintech and blockchain team. So I've gotten a nice perspective of both sides of the fence on all these regulatory issues.
Thank you, Dan. And last but not least, if I get it to move, I'm having a couple of issues with the screen sharing. If you give me a couple minutes. All right, I don't know. Let's see. Good. Just two things I'd like to say about my background is that I've been the director of the Money Service Business Association since its inception in 2015. We started with 20 companies. We're now over 80 companies. And the really important thing of what we do is provide an industry voice. As Mary will talk about later, we work with CSBS on the model law. We work with their team on improvements to the licensing system. We work with the federal regulators. So it's really important to have the voice of the non-depository institutions present. So first up, we talked about going into what is network supervision. Mary, this is a really comprehensive diagram we have here, but why don't you start us off by just giving us a little bit of an overview, please?
Hopefully my lawnmower people are gone. I will stop back and say network supervision is broader than just MSBs. It's really encompassing all non-bank supervision, but at CSBS, and I'll talk about what it is, but at CSBS, we've decided to focus first on MSBs for a lot of reasons, as we can talk about later. So in 2018, the CSBS put together a FinTech Industry Advisory Panel. We felt that, especially with the OCC, with the non-bank charter and a lot of federal preemption issues coming up, and I will say that our biggest issue in the world is to preempt the preemption of state laws that we think are better off for both consumers and industry staying within the purview of the state regulatory system. So when that happened, we realized also that there were so many new companies coming into the field. I will just say, I mean, it's a little silly to call people fintechs today because isn't everyone a fintech, but companies that were traditionally not lenders or traditionally money transmitters, but were coming into the payment space and the lending space. So we convened this large group of companies, everyone from, you know, PayPal and Apple and companies like that. And we really quickly realized we divided into lending and payments. And I sort of shepherded the lending, and my colleague Matt Lambert shepherded the payments section. And both of those groups, we met in person several times. We met over a year. They put over 100 hours into it. And basically, we wanted to know what are the big pain points as you come into this industry and realize there are 50 states plus territories that want to regulate you. So they ended up with several recommendations. And on the payment side, one of the biggest recommendations was, of course, on both sides, actually, that everyone use the NMLS. And I should step back and say that the nationwide multi-state licensing system, which if you are licensed in any state, you are quite familiar with it, but that is something that CSBS owns and operates on behalf of the states. So that's something that we've almost become a tech company over on that side. And that certainly started, what, about 2008, I believe, after the mortgage crisis. So working that, and then also there should be in the money transmission space, uniform and comprehensive and streamlined laws. One of the biggest issues is that many states have different laws, different regulations, different reporting requirements. And in some cases, they may have the same law, but they interpret it differently. And we understand very clearly that in order to keep the states relevant and keep them as your main regulator, we need to work on that because it's just, you know, as companies in our space, it is a huge regulatory compliance focused world. And anything we can do to help streamline that, and both for the regulators, I mean, no one, you know, they don't have a lot of bandwidth either. So as we move forward, really, network supervision has two components. It has the networking, which is states talking to each other, talking to industry, having common goals, common ways to do things, and then the platform, which is NMLS and SES, our state examination system that we'll talk about in a minute. So I think this chart, and we'll talk a little bit about what it is when we you know, get a little deeper into it, but we feel like then one of the biggest things that the company said was, you need a model law. So a few years ago, we put together a model law using just regulators, put it out for comment, and obviously we got a lot of feedback, and quickly realized this cannot be done in a closed room with regulators. So we put together what we call the Regulatory Industry Clearinghouse, which we'll talk about in a little bit more. And the model law really is a product of industry and regulators. And then all of these other things, these are more the technology around it. And we see that as a big picture. So we're going to talk about all of these things and then get a little more money into the money transmitter law.
Thanks, Mary. I believe that Maria has a panel for us to help us see what our audience background is. And if you could let us know which of the following, if any, components you are familiar with: MMLA, which is the multi-state licensing process; SES, which is the state examination system; one company, one exam; or NMLS and NMLS modernization. So you know that we're not having our afternoon happy hour trying to get through all of these alphabet letters here. So if you could complete that, and we can see where we stand there. Dan, while we're waiting for the results there, maybe you can share some of the pain points that this process is trying to alleviate for companies.
Sure. So in the Wayback time, let's say around 2002, every state basically did paper applications. They didn't necessarily communicate that much with each other. And so if you were an MSB, you'd put together like a 6-inch thick binder, and then you would FedEx it to a state and then to another state, and then you'd have to change it in between states. And so just simply getting your applications in required a lot of man hours, and which incidentally often also requires a lot of money, because too often MSBs need help from external help from consultants and lawyers. And, that is probably the biggest gating item right there. But also navigating the differences between the laws was very, very difficult. And then once you got licensed, if you were, say, a MoneyGram or a Western Union, you're licensed in 50 states, you've got a near continuous cycle of exams. You'd finish one state exam and you'd be already fielding questions for the next state exam. So being in this industry was very, very burdensome from a regulatory perspective. I'll also just say really quickly that, these regulations grew sort of organically. Before we had the Uniform Money Services Act, the individual state, like check cashing, sale of checks acts and so forth, grew out of banking laws. And so a lot of the regulations were, a light version of a bank charter. And in the MSB industry, especially one that evolved very quickly as technology evolved, it was very difficult to for the laws to keep up and the methods of getting licensed to keep up. And, in the banking world, you had federal preemption and branching. So you could have one state regulator or a single federal regulator, whereas with money service businesses, you'd have 50 state regulators, and we still have that. So when the first version of NMLS came along for mortgage lending, CSBS and state regulators got together and said, hey, this is a great idea. Let's do this for MSBs. So we expanded it, and it has helped streamline a lot. And it's actually really nice to see NMLS evolve, and the addition of SES and MMLA are just further steps we keep taking to streamlining and making efficient and less painful the entire process.
Thanks, Dan. It looks like most people have heard of one company, one exam, but we have less than 40% on our other topics. So I think it's good if we spend a couple of minutes talking about the processes, what they're doing and what the benefits are to the licensees. So Mary, I'll put you on the spot and talk about MMLA, the multi-state licensing. And, you know, I think if you have the current number of states where that's allowed, that would be helpful as well.
I think they're gone now. We have 31 states that participate in MMLA. And actually, this is really interesting because it didn't come out of CSBS, probably just because we didn't have time to do it, but it came out of the state of Washington. And they really just started working with other states and getting states joining. And what it is you go into NMLS and say you want to apply, and this is really like for new licensees. Once you've been licensed, you know, this process doesn't really help you, but to get a new license, you're coming in, you're brand new, you're setting up your licenses. Let's say you want to get licensed in 10 states. You do one application at MLS, which is true anyway, that we only have one application, but you submit it to, they will assign a lead state. And that lead state then goes through and goes through the first part of the, pretty much everything that's not state specific, you know, your financials, your auditing, your everything that you need, your control people, and they approve it. And once they approve it, those other 9 states approve it too. And then they get it and look at a phase 2, we call it, and anything state specific they look at. So with 31 states, right now it has lessened the application time by about 30%, and we're still working on that. And we want to obviously get all the states, but it's really just something that we really want to, you know, build into NMLS. That's part of our modernization efforts, but it's something that, you know, states have really gained by, and it's constantly evolving. And that's one thing I'll say about, certainly with this technology, obviously you can't just build something and leave it there, because in a year or two, it's going to be old. So we do constantly try to do that. So I think we started with 7 states, the original 7 states. I'm pretty sure Texas was one of them, and up to 31. So it's helpful and gets really great reviews from industry, because it does save you a lot of time.
Okay.
And I'll just chime in real quick with highlighting kind of, from my perspective, the big benefit to MMLA, as opposed, like, you can submit an application in NMLS and then blast it to multiple states, and that's fine. But each state then is evaluating your application separately. MMLA has the states that are in agreement. One state will take the lead on this portion of your exam, say the background checks for executives and owners, and another state will take a look at your financial statements and so forth like that. They kind of divvy it up so that it's more efficient on the regulatory side, which actually makes the process go faster for you, the applicant, because let's say you're doing the 10 states, they're working sort of each on a piece like an assembly line, and the whole thing goes through much more quickly, and it's much easier to just submit to those 10 states.
And they're working to a common set of standards. So they're not looking at it
Right.
differently, which is one of the big issues, obviously, that people run into. Yeah.
Thanks. I'll start off on NMLS modernization. I guess I'll go backwards in the circle. But one of the things that we are part of here at the MSBA is we have put forth our comments on the NMLS modernization. So in moving forward to streamline and correct the pain points of entry, and a little bit more, we'll talk about that with the model law. We've been able to gather input from the members on things of, what are key requirements, what are requirements that don't change depending on your business. So companies are putting forth that information to help streamline that. So hopefully we'll see some of those, the benefits, I'll say, of all of that data normalization coming, and clarity there. And there are some components in that process, for example, Kiwi. And I don't know if we should talk about, I think we'll talk more about that with the model law, but Kiwi is the key individual wizard. And later when we talk about control persons and pain points, that is a module. I like to think of it as a standalone module that will be available to companies, help them with the whole, that in conjunction with policy changes will help them with change of control and monitoring control person. So that's a great one as well. And, oops, sorry, I went down. The other component, one company, one exam. Mary, do you want to talk about that or?
Sure. This is one of our big efforts. It's been incredibly successful. And now we're moving to do it in mortgage also. So as Dan alluded earlier, when you're licensed in a lot of states, you are constantly having examinations. You turn around and you know, you may even have more than one at a time, which we try to organize, but it doesn't always work that way. And again, even though each state's looking for the same components of the financial standards and health of your business, they may look at it differently. They may ask for different reporting, different questions, et cetera. So what we decided to do, put together one company, one exam, and it is any company, any MSB company that is licensed in more than 40 states. There are 74 companies. They get one exam a year, and then there is a moratorium, a state moratorium on having any more exams. I believe it's 12 or 15 months ahead of that. So that is, you know, and then the states share the examination. So in 2021, it resulted in a 78% reduction in examinations. And as I said, we had 74 exams. So it's been extremely successful. We're constantly, you know, working on it and making it more streamlined. And as I said, we're trying to also move it into mortgage, which is a much bigger bear to do. We just finished our first big pilot of mortgage licensing. But we think that's been, you know, very successful and certainly welcome because obviously, you know, one set of questions, one type of report, one head person to deal with. So that's been a very big effort of ours. And we do have to move it into other companies too. I mean, at this point, it's a matter of, you know, it's got to be the bigger companies, but at some point, depending on how streamlined it gets and the benefits of it. And our states, we've focused a lot in our states on making sure they have the laws and regulations available to share information and to accept examinations from other states. And of course, they can only do that just like on the licensing when there are common standards. So that state A knows the state B is going to be looking at the same things as me. So I can very confidently accept that examination. So that's really, you know, again, that streamlining and that sharing of resources.
All right, thank you. The last one is SES, the State Examination System. And this is an automated system that both the regulators and the licensee use. I know that from an MSB perspective, the involvement, I'll say, and usage of the system was low last year, was only about, I think it was under 10%. Mm-hmm. And there was a couple of different reasons for that. One was that, you know, there were other training initiatives going on by the MTRA, and they did not have their examiners time to train. Those that have participated in this have found it very beneficial. Again, it's that whole item where you can, during the exam, you upload a set of documents, and that's available to a number of others. There is a big push this year to, I'll say, educate and provide information to companies to encourage the regulators to participate in the SES system. So, you know, hopefully that also will move along. That's another key component. And I think that ultimately you'll see it used in the one company, one exam, but it's just not quite there yet. Dan, I don't know if you work with any companies that have utilized these exam methods, or if you have any comments on that, or.
Yes and no. So most of my clients, well, let me put it this way. I have not dealt with a client who has required my assistance with going through SES and a multi-state exam, which is probably actually a good sign. I, you know, get called in when there's a problem, right? So I have some of my own personal thoughts. I can't really speak for our clients. I think all of this is a really good move because of the things we've already talked about. I will say, as a quick aside, what I mentioned to clients when this comes up is the fact that SES is intended to also facilitate tracking of consumer complaints is just something to be aware of, because that's a change of how your regulators are going to view consumer complaints. It used to be that like a consumer in Texas complains to the Texas Department of Banking. Texas Department of Banking sends you a letter, makes sure that you've resolved it, and then that's it. Now through SES, there will be sort of information on the tracking of these consumer complaints that may be available from regulator to regulator, which is both good and risky for the regulated industry. So it's just something to be aware of.
Go ahead, Kathy.
I was going to say that is an excellent point, Dan, because I know here at the association, while we are supportive of that technology and tracking, we are a little bit skeptical until we see what the definitions of that consumer tracking will be. Right now, the states that are actually using it are not allowing the consumer to sort of type right into that goes to show you my age, enter right into the database. They have to go through, the normal process and the normal regulator. So there is somebody taking, an intake process. But we are concerned when that intake process becomes a little bit more automated, because we did see a lot of intake problems with this, and we still do with the CFPB's consumer complaint system. So, I think as you move forward, there's always a couple of bumps in the road, and we're here to try to make sure that, companies are not affected, but consumers are. So that is a good point. Thank you for bringing that one up.
Yeah.
To the extent that it's comforting at all, I can say that, the states, even before this idea came up, the states were talking amongst themselves. For the 7 years that
we're very surprised by that.
I mean, for a while I was at Texas, we would have a monthly call, and, it was attended, everybody was invited, all the regulators, and it was never 50 states on any given call, but it was a lot of them, and, whoever could show up for the monthly call. And we would have an agenda that involved, like, hey, have you heard about this, company, Gemini? What are they about? And then we would all talk about it. And consumer complaints could potentially come up. This is just a way of sort of streamlining it, but on the other hand, we also don't want it to become a regulatory version of Yelp, where, you just start getting 1-star reviews that the regulators are sharing.
Right. And I think, we've paid a lot of attention to CFPB, and we obviously work closely with them. So all these are points well taken. I should have said earlier when Kathy mentioned MTRA, and so CSBS has sister groups. The MTRA is one of them, also in the mortgage world, ARMOR, in the debt world, NACARA, and in the consumer finance world, NACA. And those are the regulator groups that focus on those license types. So those really are our sister organizations, and we work closely with them. So for instance, if we're developing common examination standards so that we can better use SES, and the MTRA already has them, we work with them. So we're separate entities, but we're very aligned. And that's an important part of what we do.
Okay, so we talked earlier about the glue that sort of holds that together. And Mary, if you can take us into the MSB Model Law.
Sure, Kathy. Do you want to talk about how it came about first, or were you doing that later? I think there was another slide, or do you want to just, because I think we need to talk about how it's developed. We
have the adoption process later, but I think you can give us some insights into
well, as I mentioned earlier, we realized very quickly this had to be an industry regulator effort. And so Kathy was one of the folks representing her association. That was one of the industry groups. We had a lot of big companies and all the big trade associations, plus a wide range of states, Texas, California, North Carolina. I think there were, 8 states and 8 industry members, Kathy, I believe.
Yes, there were 8 states and 8 industry members that met over a year period. And we met mostly twice a week for an hour to 2 hours. There was a significant amount of effort and discussion and I'll say compromise.
Absolutely. And so much work went into that. And it was really, but I think we really count with, obviously the word compromise is important because industry gave a lot and regulators, obviously, consumer protection is their number one. But so the model law, so basically drives consistency between the states. Again, fewer calls for federal preemption. So right now, even in Congress, there is the Loomis bill that's focused on cryptocurrency. But one of the things in that bill is, if you will, a SAFE Act for states, meaning the way we went on mortgage, where they're saying that states have to, have common standards within 2 years. And hopefully that would be our common standards, but, we're just not a big fan of giving federal authority to what we think is really the state focus and the better way to go. So again, the streamlining, the things we've talked about, and to enhance consumer protections. So why are we changing? I mean, we've really already said too many disparate state laws, too many disparate interpretations of those laws. And then also the licensing and supervision, as we talked about before in that diagram, the interaction between NMLS and the exam process. And really there has to be clarity and there has to be uniformity, but there will always be slight differences. I mean, we are a country of independent sovereign states. But we really are dedicated to moving towards this. And also, so as I said, it's a big effort between regulators and industry. When Kathy mentioned those 2 meetings a week, there was the Friday meeting from 3 to 4:30, which is a really tough time slot. And there was some very, very in the weeds discussions, lots of follow-up work, lots of real dedicated folks, I would say. And we're very happy with the outcome. It was approved by our board in August of 2021. So it was a little bit late to get started in a lot of states, and we'll talk about the approval process in a minute. But, we've spent a lot of time working with not only our own members to, because it is a very dense 50-page law. There's a lot in there. It's a big lift. But also other groups, the bankers, the card coalition folks, the consumer advocates. We didn't want there to be surprises because the legislative process is hard enough. So we've been working on we've been working on it for a long time.
Yeah. Dan, as a former regulator, I mean, maybe you can talk a little bit about how, you'd have to take the law from the legislator and work with your legislature in order to enact that, and why some changes may come up. We'll talk about the adoption process, but I think it's important to set that stage.
Right. So I'll actually back up and give a little further context that I think is important here, which, for those of you who don't already know, there was there's an organization called the Uniform Law Commission, and it's an independent organization that basically writes laws that, at least as they view it, are the way they're supposed to be, sort of a platonic ideal of the law, right? And they don't necessarily always hit the mark, but they try, and they get experts, and they try to get people from the industry. And back in 2002, they started the process for a Money Services Act that would be a model law that they published in 2000. I think it was 2002, and then they amended it in 2004. And I think 17 states adopted it, something like that, out of the gate. And the states that adopted that exists, those are the laws. That's the basis for the money transmission laws on the books in those states right now. I will say what the Uniform Law Commission didn't necessarily do a great job of is inclusiveness. When they were drafting up their cryptocurrency law, I was still at the state of Texas, and I attended one of their meetings to give some input, and I was the only regulator there, and they were all thrilled that I showed up because I was the only regulator they had had at any of their meetings on this law. So this just conceptually from the start is a whole generation better, because we've had buy-in from both regulators and the industry. Compromise was the word that you both used before, and the idea of the sausage making of making a law. When there's compromise, nobody's happy, everybody's angry, but everybody can live with it, is kind of the end result, right? I think we're a little bit better than everybody is angry in this case, but I think if you read it and you know the existing state laws, this would be a great move towards standardization. And that's why I love it, even though, to be honest, if it passed in all 50 states, it would reduce the amount of business I do. But I think it's a very good thing for the industry and the regulators. Now, for the process, and this is where some things remain to be seen, ultimately, each state legislature has to pass this thing. And what will probably happen, similar to when the Uniform Law Commission model law came out 20 years ago, the regulators who like it will find a sponsor in the legislature to sponsor it, and then it goes through the normal legislative process. And, you know, the number one problem with legislators is they have a tendency to legislate. They, you know, there's a very good chance that things will get changed, hopefully only in small ways. But to give you an example, Texas was one of the 17 states that adopted the Model Money Services Act. If you were to do like a red line comparison of the two, it would be all red. This is the chance we're taking. This is the dice that we're rolling. But like I said, I think this is a good thing. It's a very good step, and there are compelling reasons that the regulators can take to their legislative champions and tell them, look, we should adopt this. We should adopt this as written or with these minor changes, because part of the purpose is standardization across the country.
Yeah, and I think that, you know, that whole nationwide project, I mean, when money transmission laws were originally designed, you know, many companies were not national. They were very single state specific. And you're having to go into those state laws that maybe were developed a very long time ago with regard to, you know, how they handle things. For example, and I can't remember the state offhand, they may assess your surety bonding based on how many branch offices you have in that state. Well, if you're a large digital company now, such as Wise or World Remit, you no longer have you don't have physical branch offices. And there was a disconnect there between how do you ensure that the state can protect the consumer in those situations. So that's just sort of a very, you know, I think simple example of how the laws were out there. Some of them were dated, some of them have been updated, but really to keep people in sync, this is critical. Next, we're going to talk about, Mary, you're going to take us into the whole adoption process. And I think it's worthwhile to understand really those steps. And as a potential consumer and or constituent out there in a state, you may be called upon to have your voice heard locally to help support that. So I think that's important. Mary, over to you.
Kathy. So as I mentioned earlier, it was approved by our board finally in August. And, you know, first we focused on educating our regulators. And as I said, we'd already started kind of getting a wide range of industry stakeholders engaged, both the ones that worked like Kathy on the actual bill and other folks, you know, keeping them informed about what was going on. So the Nls Modernization Gap Analysis, that happened because when Kathy and the group were working on the model law, the first half was finished first. And that was really the licensing provisions, you know, all the things you'd need to do as you went and got a license, you know, what your background check would have to be, you know, what kind of information you have to have, who are the control people. And that was done quite early. And so since obviously this was taking a long time, we had our NMLS folks and others in our policy group, we reached out to every single state and really went point by point at what that model law would look like in licensing, comparing it to what they have today. So we get a gap analysis, they could see how many changes they had to make. And that, you know, obviously was a big effort. And I think we're very big on change management and change management processes at CSBS, which can sometimes take over your project, but it's kind of an interesting way to look at things. But I mean, it was very helpful. And also people are busy, whether you're industry or you're regulator, and it's really hard to get people to focus, and because they have so many other priorities. So that was a really interesting project, and we got a lot of information out of it, and different pain points that came out and things maybe we could even make better. So then as the full law was then finished and adopted, outlining the adoption process. So how do we do that? We really, first, again, working with the states, we have held quite a few workshops with our states, going through different specifics of it, and then really talking about, all right, can you introduce the bill this year? And we, can you do it? What year do you think you can do it? How can we help you? How can we get industry involved? Because I think, as Dan said, the legislative process, it's probably our biggest obstacle. It's not that people, because again, we don't have a lot of opponents on this. Of course, states will go in and make specific changes, but it's a matter of priorities. When an agency has a bill, it has to go through the governor's office and become part of the governor's package. And there are a lot of competing priorities. So really actually we had a board meeting today and we were talking about this, and one of the states just said politics is our biggest problem. And it's a state that has a bill that's just sitting there because they can't get it to go for no particular reason, but just, some states it's very hard to get something passed. So that was, what are our obstacles? So we've been, as Kathy knows, we have a pretty big industry group. We actually meet with them weekly just to do check-ins and figure out, do you have a contact in this state? And, and I think the industry is very, they don't want to step on their regulator toes, but also on the other hand, it has to be a joint effort. So the industry engagement, as I said, that's what we've been doing for a while now. One of the things we just did at our board meeting was really talk about, okay, these obstacles are really there, and it's difficult, both from a bandwidth situation or a priority situation, or perhaps the regulator doesn't have the ability to get a legislative package in. This is an election year, there's so many moving parts to this. So, how more can we help industry gear up and work, more intensely on this? And so it may well be in your state, if you're active in your legislature, please support it as we go through. And then, so state adoption, obviously if they're successful in passing. So this year again, we had a very late start. Arizona is the first state to pass the full model law, and that has been enacted, I think, 2 months ago. Right now in Alaska, they've got a full model law moving through their legislature, and then about a half a dozen other states. And this was really just a matter of, what can we get done this year? If we have an open bill, what can we put in? So some of the things like, the control provisions, and the control provisions are pretty interesting because that's a huge pain point for industry. So basically, you have passive investors. And so does a passive investor have to get a fingerprint background check? And many states would say, well, they are an owner or an indirect owner. So we've really worked to smooth out the details on that. Kathy mentioned Kiwi, which is how you do that. So that type of thing. So we're really hoping, we're working now, obviously, on 2023. We are focused pretty careful. We know a lot of states have legislative packages, but I can say, for instance, I know 3 large states had legislative packages this year, and they just couldn't get it through their governor's office. And so that's where, maybe industry needs to come in and talk to legislators and introduce it. It's just got to be a big joint effort. So, as I said, we've laid the groundwork. What are our other allies? You don't want the consumer advocates to hop up at the last minute and say it's a terrible thing. So, I think we've done a lot of that. But it's really just, that sausage making of legislative passage is, any of you who's worked with your state legislators know, not quite as bad as Congress. I will say that states do a lot more than Congress, but it's still a big lift. And that's something that we're looking for any help we can get, quite frankly.
Thank you, Mary. I think that is good. And I think for people to realize, the state legislative process is generally very focused and short term. Most states are start in January and they end the end of June. There's a couple stragglers that sneak things in on us that we're not happy with, but for the most part, you're very focused at the first part of the year. And also, we have states, as Mary said, we've reached out to states to put forth our letters of support. For the association, one of the things that we always note is that some of our members are small to medium-sized companies that, are not national, so they may not benefit from the net effects, I'll say, of all the changes. Mm-hmm. And we need to be sure that we give them ample time to transition. For the most part, the way the law is written is that it's 6 months after the regulation is adopted, not necessarily the legislation, because once the legislation is written, then the state has to outline the regulation specifics, and then within that process, then there is 6 months or the renewal period. So, you know, generally, I think companies will see about a year period, but they do have to stay on top of that there. Dan, anything to add from Texas's perspective?
The only thing I'll say is sort of one of the quirks of Texas legislation is that we only have session every other year,
Right.
so it takes a little more planning. But yeah, everything that you've both said is, you know, the same thing from there. I can tell you from my personal experience being over there, you know, the Department of Banking has good relationships in the legislature, and they generally do a good job of finding a good champion and, you know, sort of helping shepherd any legislative changes through. So to the extent that you get buy-in from Charles Cooper and the agency there, you have a pretty good chance of getting the bill relatively unmolested through the process.
And Charles is a very big champion of this, so he's been working on it.
All right. This is another way, but I think it's a good thing, and it's the key administrative provisions of the model law. I don't know if you want to just hit on some of these relative to the pain points that we're fixing in the new model law. Dan?
Yeah, I'll jump in here. And as quick background, when we were prepping for this, I brought this up. It's I like to give this little spiel to my clients sometimes, who a lot of times in this fintech space, you've got people with really great ideas and they just want to get to market, and that's what they do. They're business people or they're tech people, and they don't understand why suddenly we have to stop and talk about 50 state licensing regimes. And they're like, well, how bad can it be to get licenses? Let's just get them. So it's helpful to frame everything. I mentioned earlier in the session, but I'll hit it again, that money transmission and money services generally are an offshoot of banking, right? And so if you know anything about the regulation of banking, there are, you know, very, very strict requirements. You have to have, you know, certain capital requirements. All of the officers and owners get vetted, and on and on and on. Your parent company is going to be regulated by the Federal Reserve Board, and it's all because we need a safe and sound financial system that everybody can rely on. You know, you want to be able to go to your bank on the corner, withdraw money, and know that your money is going to be there, among other things. MSBs are an offshoot of that. So the licensing process is really a bank charter light. So keeping that in mind, I think, helps set the table and give you perspective about why, like, for instance, on this slide, we've got, you know, your criminal background checks, your credit check, you've got to vet your control and key individuals. And then afterwards, you've got ongoing supervision, reporting, and record keeping requirements, and so on. That's never going to go away. Just to be absolutely clear, the people who are calling for a federal preemptive solution, you're just going to be replacing federal, you know, state regulations with federal regulations, but they're going to be similar to this. This is just what financial services regulation is like. So to the extent we can fix any of that, that's particularly difficult. This does some of that work. So standardization is sort of the umbrella idea in my mind. Things we talked about earlier, and some things that we kind of alluded to but didn't talk about, like, as an example, I recently had interaction with a particular state on behalf of a client where we were talking about an exemption that was written into their statute. And it's the same exemption that exists in 5 other states that interpret it the way I believe it should be interpreted. And this one state said, no, we don't view it that way. We don't grant that exemption. I just had to scratch my head and walk away. We're hoping that with a standard model law that everybody agrees to, will reduce instances like that. Or speaking of exemptions, when I have to guide a client through how not to trigger licensure, if you've got wiggle room to not be an MSB, great, we can guide you through that. But there is no like single exemption other than the bank exemption that works in all the states. If everybody adopts a model law with the same exemptions, then it's much easier for you to plan your products, getting them to market, for instance. Some of the specific things, I won't go through the entire model law, but for legal nerds like myself, there are some cool key provisions in here. The rebuttable presumption of control is a great one. As it stands right now, the state laws are written in a way that, like, if you're an owner of 10% of the company or the ultimate parent, you're a control person in most states. Some states it's 25% or whatever. But, if you meet that threshold, you're a control person. You have to go through criminal background check and so forth. But in the model law, it's only a rebuttable presumption. So now, Kathy mentioned passive investors earlier. If you're a passive investor and you're not going to have any hand in controlling the company, well, you don't pose a consumer risk or an AML risk. So why do we need to go through the whole change of control process if you want to buy into the company? So this allows a mechanism to avoid all of that trouble, which is a benefit to both the regulator and the licensee. Standardization of the exemptions I mentioned is great. The net worth provisions are going to be standardized, which is like this slide implies, it for some states it raises the bar, but for some other states it actually makes it a little bit easier. Like I used to like to tell people the state with the lowest net worth requirement, I believe, was Hawaii at $10,000, and Utah was the highest at $1 million. So if you want to get licensed across the country, you need $1 million to meet everybody. But if you're going state by state, you have to figure out what states require. This would just set sort of a standard $100,000. But there is a tangible net worth requirement, which I think is a good idea, even though some people may object to it because a lot of states do not have that currently.
And I think also with the net worth, it's interesting because it's a sliding scale. So, a new company does not need the same net worth as PayPal. You know what I mean? So, and that's a big issue. So especially, for smaller companies, as you grow and hold more consumer funds, then yes, your net worth should grow.
Very good point. When I was still working for the state of Texas, we tried really hard to come up with a bill that would have provided an on-ramp for small startups. Ultimately, it didn't go anywhere.
Yeah, that's a tough one. I know a lot of states have tried that because it's it makes sense.
Right. But as you said, this sliding scale, if you're a startup, having a $100,000 minimum net worth is a lot easier than if you're, a bigger operation.
One thing, permissible investments is a big deal, and I'm most certainly not an expert in that. But one thing that industry brought to the table and really had to educate the regulators on, and they walked away thinking, some people just changed their mind totally thinking this is a great idea, was the use of letters of credit as a permissible investment. So my rudimentary understanding of it is that maybe it's very much of a banking thing. So really we had some experts come in and talk to our regulators who are really non-bank supervisors. And they all walked away saying this is a great idea. And so it may not be for everyone, but if you're a larger company particularly, that may really be a good option for you. And the states like it because if you go into bankruptcy or there's issues, basically the letter of credit goes, instead of everyone fighting over that money, and so maybe the first state jumps in, gets it, it's more equitable. So it really makes a lot of sense, and it's something that just didn't exist before in the non-bank world. So, I mean, as I said, this was such an effort of education coming from both sides.
Yeah, I'll just jump in too. I went to Raising the Bar here. Dan was talking about some of that stuff, but we have a clearer picture the model law provides. What's regulated, what's not, the definitions, permissible investments, the safety and soundness provisions are consistent. We did add and get states to buy into things like cash in transit, so that being able to include that. Some states, for example, if you are in a traditional retail establishment and you're using a armored car to transport your money to the bank, some states wouldn't let you count that. Even though you've documented it, it's gone. So there's some small things there, even for people that are working on the cash side, that are beneficial. The other big thing I think is important is that authorized delegates has a consistent definition now, or agent of the payee, however you want to call that. Some states had a clear picture. Some states you had to write to them and ask for their interpretation. So, there is a benefit there. I'm going to get us to the next slide because we're nearing the.
I think you're on mute.
Yep. So future of MSB supervision, I think if you take away our current environment is manual, supervisory, calendar year exams, 50 sets of standards, and you will see significant changes. The supervisory system will be streamlined. I think both regulators and industry are committed to that harmonization and collaboration, and hopefully both the regulators and industry will benefit. I think we're almost at the end. We've talked about this. If you have questions, I've put up here the link for where you can find the actual model law and FAQs on One Company, One Exam. Also, MSBA information about membership, how to sign up for the daily news. I will turn it over to Mary and Dan for any final comments. And thank them for being great panelists.
Well, thanks for having us, Kathy. I appreciate it. Obviously, if there's any questions, please feel free to reach out. I appreciate being asked to do this. And again, this is a long haul. And if you're at all involved or hear about this, any support or reaching out to your state legislators would be certainly welcome, because I do think we will get there. We are very committed. Our leadership is very committed to this, but it is a tough thing to do.
I just have two closing points. One is, sort of to quote from the musical Hamilton, that you want to be in the room where it happens, right? The decisions are always made by the people in the room. So get involved. If, to whatever extent you have any opinion on all of this, get involved. If you don't have an opinion, I suggest you talk to someone, get an opinion, and then get involved. And then the second thing is, a plug. I promise Kathy didn't put me up to this, but a plug for the MSBA is a great way to get involved. They do great work with both keeping you up to date on the developments in the industry and legislation, as well as advocacy. So they're a wonderful organization.
Thank you. And the one thing I'll leave everyone with is, John Ryan was the president and CEO of CSBS, and he was extremely committed to making the state option work better and worked very hard. And I think, we are all a little bit sad that he is not with us any longer, but I think that, he left us a mission to move forward. And I think that both industry and regulators will benefit from that vision. So thank you, everyone, and enjoy the evening.
Thank you so much.
Thank you.
Thank you, everyone. Thanks to Kathy, Dan, and Mary for being part of our first session. Tomorrow, I invite everyone to be here to connect and join us in our second panel, Business Advice from Compliance Professionals and Legal Counsel. Hope everyone enjoyed our topic today. Thank you very much for joining us. Kathy, Mary, and Dan, thank you so much for your knowledge and participating in our session. Everyone, see you tomorrow. Thank you very much.